All right, hi everyone. I just want to ask all of the panelists to now turn on their cameras and come join us. We're going to wait another minute or two as participants start to file in. And just so everyone knows, we are also live streamed on Facebook. So if people reach out and want to be able to participate in this, they can also watch us on Facebook. So we'll just give it 2 more minutes and then we'll get started. Okay, hi everyone, good evening and welcome. My name is Rebecca Fischer and I'm the Executive Director of New Yorkers Against Gun Violence. Tonight's program is part of our statewide education initiative called Connecting Communities to End Gun Violence. We've been bringing together New York community leaders, survivors, lawmakers at all levels of government, policy experts, mental health professionals, and many others to discuss gun violence and the solutions that are saving lives. Over the past year, we've had numerous statewide events and regional forums, and with your support, we will hopefully be able to do many, many more. One of the many reasons that we launched this initiative is because in New York State, we have been a model to states across the country, looking to implement effective gun reform policy solutions and violence intervention programs. And during the past decade, to just name a few, New York has enacted a universal background check system, we've banned assault weapons, we've passed laws that prevent domestic violence and keep guns away from kids and individuals in crisis. And most recently, we passed a law to sue the gun industry and ban ghost guns, among many other measures. Comparatively speaking, these laws and programs have been very effective. And New York State has one of the lowest gun death and injury rates in the country. But while we do have to acknowledge our progress, gun violence truly does remain a public health crisis in New York State. And it's largely caused by guns that are coming from out of state. Over 85% of the guns used in shootings here in New York originate out of state from weak gun law states. So while we keep fighting for better gun laws nationally, the gun lobby continues to keep attacking the strong gun laws that we do have. And New York State has been the gun extremist battleground for Second Amendment litigation. And quite frankly, it's been really ugly lately. Tonight, we'll be discussing the US Supreme Court's decision in New York State Rifle and Pistol Association versus Bruen and its impact on gun safety laws, not only in New York, but across the country. We'll also learn about New York State's rapid legislative response to the decision and the gun lobby's attack on our new laws and the new and concerning law enforcement challenges that we now face. So to help us break it down, we are joined by several excellent panelists tonight. We are here with Manhattan District Attorney Alvin Bragg, New York State Senator Zellnor Myrie, and Eric Ruben, Second Amendment expert and law professor at SMU Dedman School of Law, and a Brennan Center Fellow. So it's good to have you all here. Thank you so much for joining me. Eric, I am going to start with you. So let's please set the stage. Can you just give us a brief overview of the Supreme Court's decision in Bruen and just talk about what the impact specifically was on New York State's gun licensing law and why that's so significant?
Sure, happy to do so. And thank you for inviting me to participate in this incredible panel. I'm really happy to be here with all of you. So to set the stage, this case involved a challenge to New York's policy for permitting the concealed carry of handguns in public. For over a century in New York, before this case came down, there was a requirement that somebody who wanted to carry a concealed handgun in public needed to get a permit. In order to get that permit, an applicant had to show proper cause. If somebody wanted an unrestricted permit, a permit, in other words, that would allow them to carry a concealed handgun virtually anywhere, they had to show a heightened need for self-defense. They had to show that they faced security threats that separated them from the general public. Saying that an applicant was afraid that they might get attacked by a stranger, for example, wouldn't be enough. They had to show something more, like that they had been stalked, they had received particularized threats, or they carried a lot of money for their job. And in this case, the two plaintiffs in this litigation saw such an unrestricted permit, but didn't have a heightened need for self-defense, couldn't show one, and they were denied an unrestricted permit. They got licenses to carry in public, but they were limited in certain ways. They were limited, for instance, to carry to and from work and a few other places. And they argued, along with the NRA New York affiliate, that violated their Second Amendment rights. And in the opinion, Bruen, that was issued in June, the Supreme Court, in an ideologically divided opinion, 6-3, agreed with the plaintiffs that the New York proper cause requirement violated the Second Amendment. This was a landmark decision, not only because it dealt with carrying guns in public, which separated this opinion from the Heller decision, which just dealt with the right to have a handgun in home, but also because of the way that the court got there through imposing a historical analogical test for future Second Amendment cases. So you asked about how this affected New York's public carry policy in particular. I guess I'll start there, and I'm also happy to share the methodology and how that will impact litigation going forward. But with respect to New York's public carry policy, the proper cause requirement was the teeth of the New York state policy. It was the main requirement, the main limitation. And so removing that requirement to get an unrestricted permit, I think that it forced New York to rethink a lot of its public carry policies. A lot of New York politicians and New Yorkers have expressed concern in the run-up to the case and afterwards that gutting the public carry regime in this way might have public safety ramifications. And by way of further background in terms of the New York policy, and I know we're going to talk more about the response to the Bruen case in New York State, but before Bruen, there was no requirement for any training, for instance, before you could get a permit to carry a gun concealed. But then again, few people could actually pass the proper cause requirement. Fewer people could pass the proper cause requirement, so it wasn't as much of an issue. Fewer people were crossing between public and private property into businesses and the like with lawfully carried hidden guns. And therefore, there wasn't as much of a need to think through how to regulate that issue. In Dallas, for instance, where I live right now, businesses all put no guns allowed signs, no gun signs on their windows, but that just wasn't something that you saw in New York because it wasn't as much of an issue. And along the same lines, there wasn't as much thinking about what sensitive places could still be demarcated as gun-free zones. And the Supreme Court in the Bruen case blessed the ability to say that certain places are sensitive places where you can't bring guns. How broadly you can define those places is an issue that's getting litigated right now.
Definitely get to that more, Eric, but I wanted to just, before we talk more specifically about the New York implications, I do think it would be helpful to just talk about the framework and without getting too deep into the legalese and the jurisprudence, talking about what the framework was before and why that was somewhat positive analysis for Second Amendment litigation, and now what is the analysis that the court is requiring courts to go through and legislatures to go through in terms of drafting legislation.
Sure. So before Bruen, there was consensus amongst the courts of appeals, broad consensus, that Second Amendment questions should be decided according to a two-step framework. The first step is asking whether or not the Second Amendment is implicated at all. So for instance, some weapons, like a missile launcher, just simply aren't arms protected by the Second Amendment. There's no Second Amendment question. And that first step was heavily historical. If, however, a regulated person, conduct, or weapon did have Second Amendment protection, then courts were applying what's known as means and scrutiny. In short, they were asking, what's the government's reason for regulating? And generally that was to protect the people. And did the regulation sufficiently further that interest? So in the context of, like, say, a domestic violence restraining order where you're prohibited from having a gun, the government would put on evidence showing that this restriction actually keeps domestic violence victims safe. And it would be modern day empirical evidence for modern day problems and modern day regulations. Bruen said that second step, looking at modern day policy considerations and suggesting that modern day evidence is not the way that you decide Second Amendment questions. Instead, what Bruen set forth was this historical analogical test that modern day gun laws passed for modern day reasons and addressing modern day weapons have to be supported by the government by analogizing to historical gun laws. Not just any historical gun laws. The primary focus is around the time that the Second Amendment got enacted in 1791. So this new test that the Supreme Court created really upheaves the way that Second Amendment cases get decided. And there's this ill-defined sense of what makes a modern day law analogous to a law from 1791. And the Supreme Court really didn't provide all that much guidance on how to do this. They said you have to consider how and why the modern day and historical laws impinge or affected the right to armed self-defense. But considering why historical laws were passed and why modern day laws were passed, there are always going to be different reasons. Like the risk of gunpowder catching fire, setting fire to a neighborhood was a big concern back in the late 1700s. It's not as much of a concern nowadays. AR-15s.
Ask that. I mean, I think it would be helpful for the audience to hear. Did the court opine at all on the distinctions between guns that are sold today, like military style guns, and a musket from the 1700s? Or was there no reference whatsoever to the fact that we're dealing with completely different firearms?
Well, the court did say that, and the court mentioned this in Heller and said it again in Bruen, that the arms that are protected by the Second Amendment are not limited to those that existed back in 1791. So at least with respect to the scope of the right, and this is one of the ways that the opinion really stacked the deck, so to speak, against modern day regulation and for expanding the right to keep and bear arms, is that in terms of the scope of the protection, what arms get protected, that evolves with the time. But in terms of the regulations that you're allowed to impose nowadays, you have to draw clear analogies to historical gun laws. So there's a bit of asymmetry there in terms of how the court is treating the right and how it's looking at permissible regulations.
Great. Well, I definitely want to come back to you, especially to talk about the litigation that is pending now. But let's jump to Senator Myrie for a few questions from you. So the state legislative session ended in June. We worked hard together, during the session. Comes to an end. We're waiting for the court's decision in Bruen, and then the court just drops this bomb in July. So can you talk to us a little bit about, what the response was from the state government, and then, break down what we did legislatively?
Yeah, so firstly, excuse me, thank you for the invite to this panel, and it's good to be with the professor and the DA. I'll pick up where you left off. Folks have to remember that the time and the circumstance in which we were in. We ended the legislative session, as you pointed out, Rebecca, working together in response to what had happened in Buffalo, which was its own tragedy, and which had gotten a lot of national attention, but which required us to take some action. And then, of course, we were still grappling with the subway shooting that happened in Sunset Park in Brooklyn in my district, and of course Uvalde, that was preeminent in everyone's minds. And so we had some inkling of where the court was going to go based off of the oral arguments back in last November, and working with you, Rebecca, and sort of coordinating the state's efforts with national groups. You and all of us were really trying, not scrambling from nothing, but trying to respond in real time to the test as laid out by the professor, which to me, and I say this with great respect for anyone who chooses to become a federal judge and maybe a Supreme Court justice, but I believe it was a wholly political document that was not based in my humble legal opinion in constitutional precedent, and was really just a way for the court to achieve the end that they wanted to. So anyways, we were forced to now come back to session because of the circumstances that we were dealing with. Everyone was very afraid as it related to public safety and the possibility that we could have another subway shooting where instead of just one guy with a gun, we got 10 people untrained who are taking matters into their own hands. And so working together with the governor's office and with preeminent organizations like New Yorkers Against Gun Violence, we were able to come up with what we believe to be a constitutional response to what the court had said.
So that I remember that very vividly, and it would be helpful if you could just share a little bit more about what was subsequently named the Concealed Carry Improvement Act, and really what were sort of like the 3 buckets or 4 buckets that we addressed in terms of improving the law to incorporate what the justices had said and make sure that we're within the scope of the Second Amendment, but to improve the law and make sure that we're still protected.
Yeah, and I'm happy to go into that, and I'll just say as a lawmaker that the court's opinion was not at all helpful. The guidance that we needed to ensure that we're doing this in the best and constitutional way, really, we don't have the resources to do what the court is really asking us to do. What I think it requires is that every legislator and their respective staffs to be as knowledgeable on Second Amendment history as Professor Ruben here, but we all don't have that benefit. We don't have the resources to do that. So we looked at a lot of what other states did. We looked at some of the regimes that the Supreme Court had already blessed as it pertained to the licensing piece, and also the where people could carry it. So I would categorize what we did into 2 big frameworks and then some sub-frameworks, but basically who now under the Supreme Court's decision could carry a concealed weapon and where they could carry it. And so on the who piece, as you heard Professor Ruben mention earlier today, prior to this law, you had to show special cause. The court says now you basically have to issue these unless these other things are present. And what we did was to try to make that process as thorough as possible. So it requires that you meet with the state official in person. That was not a requirement in the past. Providing several character references, some access to social media, 16 hours of training, as was mentioned earlier, 2 of which have to be live fire training, also safe storage training, suicide prevention training. So we tightened up how you could get it and who could get it. We clarified some disqualifying conviction histories as well for individuals that probably should not have access to weapons. But then we also looked at the where. And the court here, I think Justice Thomas said essentially that it couldn't be the entire island of Manhattan, but that we were still within our rights to make these calls. And so we did. And, basically, if you have a concealed carry permit, you can't bring it on government property, healthcare facilities, places of worship, libraries, public parks, zoos, educational institutions, mass transit hubs, et cetera. And what I thought really, in this, again, it's major credit to Rebecca, we switched the default notice on the concealed carry permits, which is in the past, if you had a concealed carry permit, you could go on someone's personal property or their commercial property without notifying them that you were armed. And we switched that and said that the default is that there is no firearms allowed or concealed carry permits allowed, and that if you are a personal property owner or a commercial property owner, that you have to, conspicuously state that it is welcome for people to carry those permits onto the property. So we tried our best, and I still think that we did what was constitutionally appropriate. But I'm sure we will discuss that there are others who happen to disagree with us.
That is absolutely true. And I think that, there's still people who are not aware that before we passed this law that you actually could just walk on to someone's property if you had a license with a gun. And I think that the reason that this wasn't even of consideration or is not necessarily, public knowledge is because there just weren't that many people with licenses to carry in public. And one thing I do want to clarify that Senator Myrie said for our audience is just that these extra requirements only apply to someone who is applying to have a license to carry a hidden loaded gun in public. They're not the same, there's not the same level of application process or training that's required to have a gun in the home. But just like law enforcement or any security that may be carrying a gun in public, we wanted to make sure that there was new laws in place that would just hopefully make sure that it would be more appropriate to be carrying a firearm. That being said, and I have to say it, even with that training, we've seen countless times people make countless mistakes, and including law enforcement, both intentionally and unintentionally. And so, it does remain to be seen whether these training requirements will be effective, but it's better that we have them in place than not. So before I move on from you, Senator Myrie, I just wanted to ask you, just from your perspective as a state senator, what before the case dropped, after the case dropped, these new laws, what have you heard from your constituents in terms of gun carrying, their concerns in terms of public safety, and what that looks like? If you previously expected to be able to walk outside and not confront someone with a license to carry a hidden loaded gun.
Yeah, so I actually got calls and emails to my office on this specifically. There were a number of constituents that were proactively reaching out, asking, okay, so I'm hearing in the news, I'm seeing in the news that the Supreme Court is about to let guns go free all over the city. What are you going to do about it? And this was coming from all portions of my district. I represent neighborhoods that have different socioeconomic statuses, and everybody was concerned about this because particularly in pockets of my district where gun violence is more prominent and a more regular occurrence, these people were also afraid because they have to grapple with this type of violence, unfortunately, on a regular basis. To hear that the court was now going to essentially encourage the public carrying of more firearms, it was something that people weren't pleased about. I want to mention just very briefly that there was also a pocket of my district concerned about Black people and their access to having weapons and firearms, and historically how that has been cabined and how people have been prosecuted in a disproportionate fashion based on their color. And I'd say to them that it's not that I disagree with some of the historical injustices that have happened, but those I believe are endemic to the system and endemic to how we do policing more broadly than it is to the notion of firearms and the subsequent violence that it caused. And so I felt very supported by the constituents in my district to act quickly and to do so in the right way.
Thank you for that. I think that there's definitely a misconception in general that, there's a different reason for carrying a gun, whether it's illegal or a legal gun. And we know just from statistics and data and research that most people carry guns because they're trying to protect themselves. And I think that that is born out of just this narrative and misconception more generally in this country that guns protect us, that guns are needed for self-defense. And the reality is that whether you have a gun illegally because it's been, trafficked into your district, or because you went into a gun store and applied for it and have a license, the chances are that that gun is not going to be used for a justifiable self-defense situation. And I think it's really important to say that, because yes, the Supreme Court says you're entitled to have a gun for self-defense. And yes, the Supreme Court has said again that you're, entitled to have a gun in public spaces in certain circumstances. But that doesn't mean that all the public research shows that it actually will be effective. And I think we need to keep saying that. So we'll come back to both of you, but I would like to go back to Eric for a minute before we move on to the district attorney. DA Bragg, thank you so much for waiting patiently. I promise I have questions for you too. Just talking about the litigation is what, that has subsequently come up after we passed these laws. A federal judge suspended much of New York's Concealed Carry Improvement Act with a preliminary injunction while a lawsuit challenging laws unconstitutional proceeds. Can you break that down a little bit more for us, Eric, and explain what happened there? We just talked about all these new laws that passed in July, and now we have, a gun lobby challenge and these judges upstate that have decided that actually they're unconstitutional and want to put everything on hold.
Yeah, sure. And I'm going to try to be very brief because I also want to hear from DA Bragg. So there was a challenge almost immediately to the Bruen response bill in New York, and there have been several challenges. There's a bunch of litigation going on, and this isn't something that's unique to New York. And New York's litigation has been very prominent, but there are cases being brought all across the country to pretty much all weapons regulation. Bruen basically opened the door to a new round of litigation against all gun laws across the country. And judges are trying to figure out how to do the Bruen historical analysis. So in the case that you're referencing, which is called Antonuke, which is taking place in the Western District of is it the Northern or the Western? It's a district judge in Syracuse, New York, who issued a preliminary injunction just last week that barred enforcement by certain upstate New York district attorneys and police departments, as well as the New York State Police, from enforcing certain provisions of the law. So, for instance, the court said that it found that the restriction on bringing guns into parks or into zoos, I'll use zoos as an example, the restriction on bringing guns into zoos is likely unconstitutional because it's not supported by framing era restrictions on bringing guns into zoos, even though zoos existed in the 1800s. And there's even a line in the opinion saying that people might want to carry guns into zoos because of the dangerous animals. But however, the court said it's likely constitutional as regards to playgrounds because playgrounds are closer to parks and playgrounds are closer to schools. And so there's this analysis that's happening across all the different restrictions in the New York law about, okay, well, what historical law should we be looking at? What is analogous to a modern day law? And there are a whole bunch of underlying assumptions that go into making that determination. It's not an objective determination. But the long and the short is that just this week, the Second Circuit Court of Appeals imposed a stay on that order. So the upshot of that is that the injunction in that order, the halting of law enforcement from that decision last week is stayed. It's not in effect. The law is still in effect. That judicial order is not in effect anymore. And ultimately, the Second Circuit, the appellate court, is going to be the decision maker, the ultimate decision maker. And this is the same with respect to all the challenges across the country that we've been seeing. We have to wait for the appellate courts.
So if I'm like a regular citizen of this country or a resident of New York, and I'm listening to you, I'm thinking, wow, that sounds like a lot of gobbledygook. How on earth is anyone going to enforce all of this? Even as a lawyer, just hearing you talk about it, I'm like, yeah, this just does not make any sense. And I'm glad to hear that at least for now, the laws remain enforce. But, I think that this is a good opportunity to segue finally to the district attorney to talk about, how do you interpret this? How do you talk to your staff about how to prosecute? What is law enforcement doing in the interim? It's a lot of questions, but I think you can answer them.
Well, thanks so much for having me.
Thanks for being here.
And I'm was more than happy to sit back and listen and be edified by the professor and the senator. Sounds like a good show. But yeah, look, there are this has made our work harder. I mean, there's just no other way to put that, right? Starting with the Bruen decision itself. My view of the top public safety issue in Manhattan is guns. The focus there is mostly on illegal guns that are not permitted, guns flowing into Manhattan from the South and sometimes from Pennsylvania. So that is already our current situation, particularly coming out of the pandemic, with more guns available, more legal guns being sold. That was our baseline before the Bruen decision. And I think the good news, at least for us, is in the short term, our focus is still on the illegal guns, right? This is an issue that is going to, particularly if we continue to get bad decisions out of the courts, is going to become worse over time. So at the moment, the folks in the DA's office are primarily focused on illegal guns and gun trafficking. With that said, we spent a lot of time and reached out. We're in dialogue with the legislature, before the Bruen decision about legislative ideas and the statute that is in place. We are fully prepared to enforce. Should the courts continue to allow us to enforce it, and we've been talking internally about how to enforce it, and also externally about education. So I think one of the most significant issues for us are going to be knowledge of the law, right? And so the professor talked about signage in other parts of the state. I was in Chicago a couple of weeks ago, and they had signs up about, you're not permitted to carry a gun onto this private property. I was in Times Square with the mayor a few weeks ago after the city council defined the boundaries of Times Square for the purposes of the new state law, making that a sensitive area that people cannot, even with a permit, come into. And so we've been talking a lot to civic groups, community groups, business leaders, to raise the profile and say, look, this is out there. Because I think one of the most significant challenges that are going to be raised in defense is, I didn't know about this. Like, how can I be in violation, and if I don't meet the scienter element of it? And so, we've talked about that. I mean, one thing that the city in particular is talking about, so when you go to apply to get the permit, well, if we put you on notice there, much like we do in other regimes. I don't know if that's going to be universally done throughout the state. So we have people, particularly to Manhattan, coming down from all parts of the state, and where the license requirements, not the requirement itself, but sort of the process, the rigor of the process will be different. And so I think that's going to present some challenges. We also have people coming from other states, and some states have no process, right? And going back to the question, the issue that the senator framed, but tweaking it slightly, we have to think about the equity of, how are we treating people who come here? I mean, in the past, the thought was like, if you had a permit elsewhere and you just, you didn't know, you happened to show up here, we treated those cases differently than if you were here and didn't have a license, assuming that you would know the state law where you are. Also, like, what kind of gun is it? We had a matter with, someone, if you got an AR-15, maybe there's some places where you're allowed to carry those, in this union, but if you're on the 2 train with that in Manhattan, we're probably going to have less patience for what your customs are in your home state. So we're working through all of that. I guess one thing I would say, sort of in the immediacy, the immediate kind of aftermath, we've had a lot of litigation about our current docket coming out of Bruen that doesn't necessarily arise from the new state law, with arguments that the current prosecution that we're doing is invalid, arguing that Bruen created a right which we don't think it did, the unfettered right to concealed carry. Indeed, it said, look, it says we can have a regime and we're going to have one. And in those matters, the encouraging news is that we've been kind of universally successful because Bruen, we're dealing mostly with people charged with guns who did not apply, right? Didn't apply at all. So you didn't apply, you didn't even apply. It wasn't like you applied and got rejected. And then for the most part, we're also dealing with motions from people who, even had they applied, they would have been disqualified by operation of law because of a prior felony conviction or conviction for a serious offense. So those are some of the issues that we're facing. But I do want to underscore, while we're doing that, the real sort of, other thing that we kind of always remain focused on is the non-permitted, non-licensed guns, which are, those are the ones that right now we're seeing in robberies and shootings. Both of them.
I think, just from a prevention perspective, when it comes to law enforcement, if a crime happens and they happen to have a gun on them, or it's used in the context of a crime and you're coming after the fact, then a crime has occurred. But in terms of knowing whether someone is just walking around with a gun, especially if it's concealed, that there's a lot of concern, I think, there. How is law enforcement going to know whether, if they happen to see a gun on someone, is that someone that they should approach? There's obviously a lot of concern about stop and frisk being a policing tactic being used again. And so, that we're not even talking about open carry. We're talking about hidden loaded guns that may be completely concealed or maybe in a holster. What are the conversations like about that in your office, and how are police supposed to navigate that?
Right. So this is, one of the things we did at the beginning of this year, right? Because we don't oversee policing, but we obviously oversee, the litigation of whether a stop is valid. So, we retrained, all of our folks on the kind of Fourth Amendment and the state requirements, to make sure we're applying the appropriate rigor to every stop. So that was sort of the starting point for us. We have had conversations with, our law enforcement partners, and I'm, kind of very, in a prior life, I was at the New York State Attorney General's office, where we studied stop and frisk and crunched a lot of data and issued a report showing that only 0.1% of the stops for a several-year period resulted in a conviction for a gun offense. And so very mindful of sort of the efficacy of it. So it's something that we're going to kind of, keep an eye on. I think at this moment, though, my view is that the legal analysis is the same, right? So the mix of permitted and unpermitted guns right now is virtually unchanged. So, if you are a police officer and you see someone with what looks like a gun, or let's just say a gun, I think they're handling that just as they would have prior to Bruen, and that's what our conversations have been. Now, look, we talked to our colleagues in other states that have different laws, and there may come a time, and I think it's the time that at least everyone I've talked to is terrified of. There may come a time where there are so many permits that just the sheer fact of having something that looks like a gun on your hip doesn't give an officer a basis to trigger our state analysis for inquiry approach. So we have DeBoer, which is our state law, has levels to it, but we're nowhere near that now, right? Just given the mix of guns that we have on the streets now.
Yeah, and I one of the things that I also wanted to add was just that, in terms of education around this and a misconception around what's right, what's wrong, this is also going to encourage an uptick in unlawful carrying, because to the extent that people think that there's just sort of this public perception now that you can carry a gun and that there is a legal way to do it. If you're not able to go through that process or can't afford to go through that process, you may be able to justify more in your head that, well, just because I didn't go through the licensing process, I should still be able to have a gun on me to protect me in my neighborhood or on the subway. And so I think there's a lot of concern about that too. And I think it's important to point out that, for our audience in particular and for our panelists, that states that have very loose open carry, public carry laws have significantly higher gun death and injury rates. I was actually just, on a work trip, and I was talking to a flight attendant who's from Montana, and he was talking about how he thinks that the gun death and injury rate must be much lower there because, people know that they can carry a gun, and there's much less likelihood of a school shooting or something like that, because the shooter will know that they're going to be confronted by a gun carrier. And, I'm working even when I'm traveling. And so I just pulled up the CDC's statistics and I showed him right there that actually the gun death and injury rate for Montana is significantly higher than New York's. I think it's like 29% versus around 5% for New York State. So there's a very, very vast misconception around whether or not looser laws will protect you. Unfortunately, the public safety analysis and data doesn't seem to be relevant to the new Supreme Court, but it's still something that we need to be talking about and need to be educating others about. The other thing I just wanted to make sure that we clarify too is the DA was talking about how, we're trying to demarcate where the sensitive locations are, and you see businesses are putting up signs that say no guns here. The law, because it's a default presumption, actually doesn't require a business to put up a gun saying no guns here. Guns are prohibited here. If anything, they need to put up a sign that says guns are welcome here, which, we have seen a few of upstate. But because understandably, businesses are going to be concerned about confusion about that, you're going to see a lot more signs that say guns are prohibited. And hopefully, there can be more education to the public more generally that just because there isn't a sign doesn't mean that you can carry in there. You actually need to wait and see the sign or get consent. So it's confusing, and we will see how this plays out. But I can tell you, at least from my perspective as an advocate for New Yorkers against gun violence, that the gun lobby can keep coming at us and we're going to keep fighting back. And I'm glad to have all of these partners to be able to work with. So we have about 15 minutes left, and I want to open it up to questions. I do see one in the chat, and it's possible that it's been answered already, but let's see. The question is specifically for Professor Ruben, that you described in Dallas, that would allow a private business to prohibit entry to someone carrying a firearm. Could an apartment building bar such entry? So that, I don't know if you're asking specifically about Texas law or New York, but take it away.
Well, I'll say, and as DA Bragg mentioned, Chicago, for instance, you go to Chicago and there are these no gun signs all over the place. And it's one of the interesting things that just hasn't been the reality in New York. I've been living in New York for 16 years, and I don't think I ever came across a sign that said guns not allowed, but it just wasn't as much of an issue. And I think that one thing that's important to clarify is that on private property, the private property owner, the proprietor, gets to say, no matter what the default is, whether somebody could have a gun or not on the private property. You don't have a Second Amendment right to go into private property, somebody else's property, with a gun. The Constitution protects property rights too. And so before the law switched the default, property owners could say, hey, don't want you to have your gun in here. And if you didn't leave, you were trespassing. Maybe it was even a criminal trespass, depending on the circumstances. And that's the same. Now it's just the default is you're not allowed to have your gun on the private property unless the owner still has the power to make the decision of whether or not to allow a gun onto the private property. And in terms of apartment buildings, that's a much trickier situation, because there is a right, under Heller in 2008, there's a right to have a gun in your home. And and this gets really tricky with public housing, but in terms of private apartment buildings, I think there probably would be a constitutional problem if, it's a tricky situation. That's a tricky situation because it's not really a Bruen issue. It's not this June's decision. It's more runs into a problem from the 2008 decision that says you have a constitutional right to have a gun in your home.
Thank you for that. I think the only other question is just clarifying that you're talking about New York, and that answered that question. Do we have any more questions? Otherwise, I can think of at least one.
Okay, could I jump in with a question that was sparked by the questioner's question and then the professor's answer, and then it's really to DA Bragg. Would TAP buildings, like I know that when we were around the stop and frisk stuff, that there were certain buildings that allowed for certain type of access to law enforcement just based on certain levels of activity. And I'm wondering if for this question, if in that analysis of whether, for instance, someone could have a concealed carry firearm in a lobby, but not in someone's actual apartment. I'm wondering what if you guys have seen that, or I don't know.
So we haven't seen it yet. We've not really had occasion. Our litigation has been sort of on people saying, "Hey, I didn't apply, but dismiss my case." I think the courts, and I agree with you what you said about the Supreme Court and so the lack of guidance there. It's kind of like, well, what period of history you want me to pick from? This 30 years, this 20 years. Stand on 1 foot while I read it. It just didn't give much guidance. And I think we're going to be litigating a lot, as a result, as a general matter. And then I would say under the state law, one thing that I think is, I spend most of my time in New York City, but I'm told in the rest of the world, they have more kind of, standalone housing, right? And so, I would think in other parts of the country, it's just, hey, this is my home, I got the whole thing. But as you say, and I think it applies to most residencies in Manhattan, right? What does it mean? Who's got control of the lobby? If I'm a tenant, but like I've got a sort of a landlord who's saying, well, no, I put the sign up. So I think all of that is going to be subject to litigation. We've been, as we've sort of done our sort of listening and talking tour. I mean, there've been a lot of things where we say, look, we can't give guidance. Is it going to be different from a condo to a co-op to a TAP? I think a lot of this is going to be, particularly in our cases, will come up obviously in the context of a criminal case, and we'll just have to we'll have to litigate it. And to your earlier point about sort of equity and our moderator's point about stop and frisk. I mean, I think one thing that's incumbent upon us, as much as I'm concerned about, gun safety, public safety, and not just sort of the what we see in the streets, but we know just kind of, as you said, having the guns is increasing danger to oneself. But we're going to also have to use our judgment and discretion and not have a one size fits all. And it may be that, maybe the law says, maybe there's a court that says, well, yeah, you could prosecute, in the lobby, but, we find a set of circumstances where it's like, well, yeah, the person's on the way home, and is this discriminatory against someone who lives in multi-unit housing versus like someone who's sitting on their, their fronts, their deck. And so I think all of that is we're gonna have to really use our judgment and exercise discretion.
I had a question, and then we can go back to the chat's question. I just wanted to ask Eric, what other litigation has come up in the aftermath of the Bruen decision in terms of challenges to other firearm laws in other states? I think it would be helpful to just hear about that and kind of think about what is going to be the landscape for the next 20 years.
Yeah, so I mean, there's been a ton of litigation across the country, and most of it's happening at the trial court level. Just today, we got the first federal appellate court decision in a post-Bruen case. and that was out of the Third Circuit, and the Third Circuit Court of Appeals upheld the felon in possession law applied to not only violent people who've been convicted of violent crimes, but also nonviolent crimes. They did it under the Bruen framework. And most of the courts, and this is, most of the courts were considering felon in possession laws that say that if you've been convicted of a felony or a domestic violence misdemeanor, most of the courts have been upholding those convictions. But just last week, I think it was, and here in Texas, a district court struck down the restriction on gun possession for those under domestic violence restraining orders, saying that there wasn't strong enough historical evidence from the framing era that we took guns away from people who had committed domestic violence. I mean, I think that just highlights the absurdity of the way that this test could get applied, because in 1791, domestic violence wasn't even really a crime. I mean, our understanding of gender roles and domestic violence has evolved and progressed a great deal. So if that's the framework, it could lead to some shocking and non-straight-faced results. So there's been a lot of litigation. So domestic violence restraining orders, there's a district court who struck it down. That's on appeal. A lot of cases, things are on appeal. Another Texas case, also a federal court struck down a restriction on carrying handguns for those between the ages of 18 and 20, saying that there wasn't a similar restriction back in the framing era. So they're just, there are dozens and dozens of gun laws. There are hundreds of gun laws out there. They're all getting challenged, and courts are really struggling to figure out how to do this in analogical reasoning. And just as in Bruen, where some gun laws were too old, some gun laws were too new, as DA Bragg said, you got to stand on one foot when reading them. There were actually some gun laws that were too Texan. Apparently, Texas historically had strong gun regulation. But they were too isolated. And so how to do this test is really throwing a lot of the case law into chaos. And we're just going to have to wait and see. There's going to be a lot of litigation. That's inevitable. We're going to have to wait and see how the test evolves and how the appellate courts deal with it.
I mean, my philosophy, which may or may not be supported by others, is that we need to just take the reading that seems the most practical and seems the most necessary, right? Because ultimately, if we're really just ad hoc picking different historical examples, anything could happen if it's appealed up to the Supreme Court. So we just need to push forward using our common sense and our analysis of the law. Okay, 2 questions in the chat, and mindful of the time because we do want to finish up by 8. We have a penalty question, thinking maybe we can ask the DA this question or the senator. If illegal guns are carried or used in robbery in what's considered sensitive areas in Manhattan, is the penalty higher? Are they punished more severely than if it's just a concealed carry weapons violation with no additional crime?
So I can try to answer that. There's a very practical answer to that, which is that the robbery is going to be a very serious charge. It's probably going to run concurrent to whatever the weapons possession is, in effect, sort of merge. And so this is obviously a hypo, and not one that we've been presented with yet. So without prejudice to being boxed into that sort of later, and obviously mindful it's all kind of fact sensitive. I think generally when we're seeing in the way the code is written, you can do a robbery with just your sort of your finger, right? I mean, sort of tucked in your clothes, simulating a gun. But the ones with weapons, I would think we'd look at all the circumstances, and the mitigation that one might get from having a license and some of the other circumstances I said, maybe did you come from upstairs, is I say in the abstract gonna, in my mind, really kind of go out the window if you're using that gun to commit a robbery.
Right. That makes sense. And generally when it's a violation of a licensing law versus an actual commission of a crime, the penalties are stacked. They're tiered. So the last question here, I think we could delegate to Senator Myrie, just in terms of like what we looked at when we were drafting the Concealed Carry Improvement Act. He says pre-Bruen California had practical shall issue concealed carry of firearms in most counties. Just for those of you who don't know what that means, before Bruen dropped, New York is considered a may issue carry state, in which a licensing officer would have discretion to determine whether or not a license should be issued beyond sort of just meeting standardized variables. And a shall issue regime, which is essentially what we are now, has this basically like a list of factors that need to be considered, and that's it. So the question is, did we look at Southern California counties other than Los Angeles County permit applicants who meet background checks, interviews, training requirements to lawfully carry concealed? Is New York State and City looking at the California example, or did we?
Yeah, so I'm not sure if I will answer this entirely accurately, so don't hold me to this, but we looked at all of the shall issue regimes and considered what would fit best for New York. And so I think we did that on the state level, not necessarily on the county level, which is why I'm a little reluctant to say we looked at these particular counties. But certainly on the state level, there were effectively 43 jurisdictions that the court in a footnote said, we're not disturbing how they have done their processes, and that's what we've been looking at and what we drew from in this instance. And so the status quo right now is that if you do meet these new requirements that we've laid out, some of the stuff we mentioned earlier, in-person interview, training, storage requirements, et cetera, that we have to, essentially give you that license with the parameters set out in the statute.
And if I could add just one thing, California also wasn't one of those 43 states that the Supreme Court listed. Supreme Court considered it to be like having New York style law, and California is tried to pass a law through some procedural wrinkle this past term, and it looks like they're going to be trying to pass a gun law to shore up their public carry regime, most likely over the coming year.
Thank you for that. Yeah, I mean, I to the extent that we were involved in helping guide the drafting of legislation, we made a point of looking at other states' laws that were not in jeopardy of being overhauled in any way. We wanted to be able to use them by example and make sure that we were putting together a template that was within the bounds of the decision. There's a lot of accusations about us doing something that was grossly unconstitutional or outside the scope of the decision, but a lot of thought and effort was put into the drafting by the legislature, ultimately by the governor's office and experts in the during the extraordinary session, it took longer than we anticipated, in part because of how much thoroughness and comprehensiveness was put into the drafting of these laws. So we are now at 7:59. I just want to see if we have any final questions from the audience. I have not looked at the live. Let me just do that real quick. Doesn't look like it. Okay. So with that, I'm going to say thank you to our esteemed panelists and thank you to our attendees and everyone that participated. We are, we're in it for the long haul, and we're going to have a lot more questions in the coming months. So thanks for being my deep bench, and I'm looking forward to working with you all much more to keep us safe, because we need it.
Thanks for having us.
Thanks for having me.
Thanks.
Bye.